प्रतिवाद করছো আমি আর কথা এটা প্রতিবাদ করতে কি হবে ছোট কোড না সোপারে
I say on behalf of the petitioner, I pray for a short pass over lordship.
Agenda number 2.
Lordship, in this matter, my senior appears on behalf of the respondent. I pray for a short passover. Lordship. Oblige, Lordship.
Item 3, match 3 of 925.
Hello, in item number 3, I am appearing for the appellant. Senior counsel is appearing.
Lordship, myself, for the petitioner, my lordship. Lordship, here the issue is with regard to,
The issue is all very well, but what about service?
Service has been affected, my lord.
Where is the affidavit of
Affidavit
service?
of service. Already first, earlier counsel had appeared,
Had
they have
appeared.
received the
Let us-
paper book.
Let us see.
Yes, my lord. But subsequently, they stated that they are retiring from the brief. So again, we had served the notice. Registry में password.
So Mr. Sivabalan is appearing now.
No, my lord, but they have refused from taking up the brief for the respondent.
Sorry?
They have refused, my lord. In the
Where
order
is
sheet, it
affidavit
has
of
been,
service. How?
my lord, it is in register. Passover may be given in the meantime, let it come.
Next.
My-
published.
Number 4. Match 52 of 925. I am appealing for the private response. Action to file opposition and seeking extension.
That's all. Oh, extension. You're for the appellant.
Lordship, in this matter, my senior appears on behalf of the respondent, official respondent. Pray for extension of time.
Praying for?
Extension of
Time
same
for-
prayer.
Same prayer. How long? And reply 1 week. Reply 1 week. On the request made by learned advocates for the respondents, time to file affidavit in opposition is extended by 2 weeks from date, stop. Reply thereto, if any, be filed within a week thereafter. Paragraph lists the matter after 3 weeks before the next available circuit bench, subject to its convenience. এই বোর্ডটা খারাপ হয়ে গেছে অনুজ?
Item number 5. Secretary of 926.
This is an appeal against the family judge court order.
Your suit has been dismissed.
Suit has been dismissed. I have served the notice to the opposite party and date was fixed on 2nd of February.
Oh, 2nd of February.
Monday.
Let it be listed. 2nd February. Here there is no question of stay, only paper book has to be filed.
Correction. But I have served the notice to the opposite.
Mental cruelty, what was the ground?
Repulsion and purity, both are wrong.
Item number 6. Match, I am appealing for the appellant matter. Here it requires the formal paper to file it prepared because after the full dress hearing, my lord, this order was passed, thereby my petition was disputed. So I will incorporate all the document and file an informal paper
Within
within 3 weeks.
3 weeks.
And my lord, I have taken one more application under order 41 June 27. It has got to be heard along with the other.
Yes, sure. That is can 1.
Can one.
This appeal is directed against a judgment and order dated December 19, 2025, whereby the writ petition of the appellants was dismissed by a learned judge of this court. Paragraph, learned counsel for the appellants in his usual fairness says that this appeal has to be heard out. Stop. There is no scope for passing any interim order. Stop. Paragraph, as suggested by learned counsel, let informal paper books be filed, incorporating therein all papers that were available before the learned single judge. Stop. All formalities are dispensed with. Stop. All respondents are represented.
My lord, Rakesh.
My senior is appearing on behalf.
Only official respondents. Stop. Since the respondents are represented, notice of appeal is deemed to be waived. The appeal shall be treated as ready for hearing once paper book is filed. let paper book be filed within 3 weeks from date as suggested by learned counsel for the appellants. Paragraph, can 1 of 2026, which is an application under Order 41, Rule 27 of the Code of Civil Procedure, shall be heard along with the appeal. List the appeal after 3 weeks before the then available circuit bench, subject to its convenience.
Question number 7. Well, I have taken for the appellant, but here there are private response.
You have to,
Through speed post. So let it be on Tuesday.
learned advocate for the appellant says that service on the private respondents is not complete. Paragraph, as requested, let this matter stand adjourned and be listed again on February 3.
Item number 8. 9 of 2026. Yeah, I am appealing for the appellant. Service is effective, but Mr. Rakesh come to the line.
Pass over.
Item 9.
My senior is appearing on behalf
Pass
of
over.
this one.
Item 10. Dear report of 2024.
I am for the appellant, item number 10 and 11, Lordship.
Yes.
These are the two cases wherein the appellant and the victim girl were husband and wife, and because of the teenage
Yes, we remember, sir. The state is not there.
pass over. You know.
Pass over.
Yes.
Item 12. Committee Arba 6 of 2024.
May I please, my lord? I'm the respondent in this matter.
You're for the appellant. On the request made on behalf of the appellant, let this matter stand adjourned for the day.
Then on Monday, please, my lord. Next working is Monday.
Not today means Monday, sir.
I'm grateful, please, my lord. And I'm sorry for asking, please. I'm sorry.
Item 13.
Madam, my senior is appearing at this for pass over.
Chalo, pass over.
Item 14. Committee of 2025.
For the respondent.
Konta eta?
40.
Yes. 14 appellant? Not there. Pass over.
Monday, then.
14. Very well. 14. Recorded order. The appellant is not represented.
Ask for password. Monday is present.
Yes, but he is asking for not today. Accommodation is sought for on behalf of the appellant. Stop. On the request of learned advocate for all the respondents. Respondents, let this matter stand adjourned for the day. He wants it on Monday. Talk to him.
Monday.
Item 15. CRN degree 7 of 2025.
Pass over.
Item 16. WPCG 8 of 2025. But I am appealing for the petition.
My lordship, my senior appears on behalf of.
Pass over.
Item 17. Math 15 of
Keep
2025.
17.
Item 17.
Pass over. Very well. The appellant is not represented. Oh, yes, you are for the appellant. He is asking for a day's accommodation. So upon the request made by learned advocate for the respondents, comma, let this matter stand adjourned for the day.
Item 18, committee participant of 125.
Lordship, in this matter, my senior appears on behalf.
Pass over. Rakesh Kumar.
Item 19, Matt 50 of 125.
Second call.
Very good. Item number on. WPC 16 of 125.
You tell us what to do. In the first call, nobody appeared. In the first call, accommodation was sought for. In the first call, accommodation was sought for on behalf of the official respondents. Oh, on behalf of the appellants. On behalf of the appellants. On behalf of the appellants, petitioners. On behalf of the petitioners. Stop. In the second call also, time is prayed for. Paragraph, let this matter be listed again on February 3.
Item number 2, WPC 4 of.
Where is Mr. Rakesh Kumar? Normally he is here.
Virtual, a lot of matters on the principal bench listed today, madam.
I see.
7, 8 matters. It makes different benches.
Are we, is it being live streamed? Live streaming হচ্ছে নাকি?
Should be.
Pause করো।
Number 3. Matt 33 of 125. It's the limit of services. That's been fine.
How many times will it be passed over? Pass over?
Item 8. Committee 9 of 126.
We want to do this application because order is staring on my face without pleasing me as a party. We have obtained an order behind my back. By contractual, by directly.
So long as service is complete.
Service is complete, I have filed a gift of service.
Let us see.
I have filed it in the registry.
We have to see it, Mr. Venu Kumar. Affidavit of service. What happened? When have you filed? Then we have to see, look at it. We have to satisfy ourselves that service has in fact been effected. We can pass it over if you can get it. 8 passed over 8.
Item 9, WPC 43 of 125.
Tell us what to do. Tuesday. Stephen, that order, learned advocate for the Respondents was not present in the first call, stop. He is also not present in the second call. Paragraph as suggested by learned advocate for the petitioner, comma, let this matter be listed again on February 3.
Item ten. There is 4 of 2024.
Lordship, I am for the appellant, Lordship.
Yes.
Subscribe the respondents.
Item
10.
10. Lordship, item 10 and 11 are two matters, in
Yes.
which item 11 is the first matter which happened in the year 2017 and it was ordered in the year 2025. Item 10 was the
the petitioner, no, appellant, comma, let this matter stand adjourned for the day.
Item 15. Here DV 7/2025.
I for the response.
Who is for the appellant? Mr. Ajit Kumar.
Item 16.
My lord, I am for the petition. Let it be taken on your side.
Thursday. On the request made by learned advocate for the petitioner, comma, let this matter stand adjourned and be listed again on February 5.
Item 18. Mac 27/2025.
Fourth. On the request of learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on February 4.
Item 19. Mac 50/2025.
Lordship, in this matter, my senior appears on behalf of the respondent. I pray for not to do.
I told him that he is apparently stuck with some content matters before the principal bench. He is appearing virtually. In none of the matters, Mr. Rakesh Kumar appeared. Several matters were adjourned.
On the court, but only one thing, that if your lordship could direct them to produce this record, what I think. Yes. What if your lordship looks at the order dated 24/9/2025? The decision taken by the members of the council was not approved by the competent authority. They have taken this stand. Whether it has been approved or not, only that much if your lordship can.
Municipal Council.
Municipal council. Then it will be easier for your lordship to decide the matter.
Order dated?
Order dated 24/9, at the end of the 24/9/2025. Of the writ court. No. Paragraph 5.
You are for the writ petitioner.
Writ petitioner appellant. Yes, ma'am.
You were each one.
Yes, ma'am. No, that was, we had challenged the tender process. Your lordship will see your lordship's last order, my lord, which was passed at principal bench.
In is writ court. Yes, paragraph 5 of the order.
My lord.
Ki bolcho? Accommodation is prayed for on behalf of the respondents. Paragraph. We see that in paragraph 5 of the order of the learned single judge, comma, dated September 24, 2025, comma, which is under challenge in this appeal, comma, it has been recorded. The learned judge has recorded the submission made on behalf of the municipal council that the decision taken by the members of the council was not approved by the competent authority. Stop. The municipal council is directed to produce the relevant records in support of the aforesaid submission on when?
4th, my lord.
On February 4, 2026, when this matter will be listed again.
I'm grateful.
You have understood, madam? Produce the records, relevant records to support that submission.
I'm very grateful to your lordship.
Pass over দুটো আছে দেখো। Number 3.
Lordship, myself for the petitioner. Lordship, this is an issue under the Income Tax Act.
এইটা দাও ফাইলটা দাও।
Lordship, may Lordship?
Sir, just allow us to go through the affidavit.
Yes, my Lordship. Sorry, my Lordship.
One copy.
What is that? Second copy of that.
How many copies of affidavit of service you have filed? One copy.
One.
One. How many judges are there?
I have.
You are before the division bench of the High Court. Some discipline, not today.
Item number 8. Item number 8.
My lord, I am appearing for the appellant, my lord.
Where's your affidavit of service?
My lord, it is there in record, my lord. It is there, my lord.
One actor. Not today.
My lord,
Please
my lord, my lord, I am extremely sorry, my lord, because,
Is it?
no, my,
Yes, go to your institution.
my lord, my lord.
Teach your juniors. What is this? In Calcutta also, we never, unless there are 2 copies, we don't take on record anything.
My lord.
Come back on Monday, what to do? Not today.
My lord, I want to mention these matters, my lord. Uh, there were direction to file affidavit that was not filed. And in a second appeal, my lord, the registry was directed to issue notice so that I can verify the document. But when I verified the document, all documents were not there.
So it should be listed as to be mentioned.
Mention, my lord, so that my purpose is.
Item number on. 05 of.
Official respondent, my lordship, performer respondent. Appearing for the respondent number one.
But here I have challenged the order passed by the Learned Civil Senior Division. Here, my lord, the plaintiff, that is the private respondent hearing, 1 and 2, has filed a suit for perpetual invention and declaration of manufactured map as null and void. As per the local regulation, he has to prepare an appeal on that ground because I have entered into appearance and I have filed the written statement. Thereafter, I have made an application that the route is not maintainable.
Yes, yes, I've read it. Once it had come before the High Court, then the High Court sent it back,
Yes,
saying that decide this as a preliminary issue.
first set aside the order, thereafter again preliminary issue was raised, and again the same thing.
Show us the regulations, show me the regulations.
The three provision, my lord. Regulation 49.
Manoj sir.
Hey, Bonu, regulation.
49A. 49,
Before that, just show me the prayer in the plaint.
page 45.
45.
A decree be passed declaring the present manufactured sketch map of land bearing survey number 285, 286, total area 2.02 hectares situated at Bandu village and the Parajan Tehsil, Southern district as null and void. A decree for perpetual injunction against the defendant, restraining the defendants not to interfere into the long and peaceful possession of the plaintiff over the suit land bearing survey number 1 of the P, area 2.02 hectares situated at Bandu under Parajan Tehsil.
Yes, all right. Yes, yes.
Now, my lord, the total area which was allotted to the father of the respondent, that was 2.02 hectares. That was sold, whole area sold to me. My name. It was sold, sale deed also in the year 2007. In the year 2007. Now they are nobody, they are the encroachers, mere encroachers. They are claiming upon my name.
Yes, show me the provisions on which you are relying to.
49. 49A.
Yes,
The regulation 49A, why I am saying, because in the year 2015, re-survey was conducted. In the re-survey, the land was regularized and provisional map was issued in the year 2019. Because every 30 years, the government used to re-survey the village. It was done in the year 2015, after purchase of my land. In the year 2015, the re-survey was done. 2019, the new map was given, everything, because for everyone, it is given by the settlement officer. This has to be, this usually done by the settlement officer. So as per the provision of 49A, he has done this. Settlement officer.
Yes.
Subject to the rules made.
yes, next which rule?
This is that chapter 6 is there. Next, chapter 6, revenue survey and settlement in non-urban area.
Yes,
Under this,
yes.
next, if it is done under this regulation, under this, then 21E is the appealable.
28(1)(e).
28 says is appeal.
Yes,
28 says about the appeal. Stay was otherwise provided in this regulation, an appeal shall lie from every original order found
Yes.
under this regulation or the rules made there. 1E says here.
yes, settlement commissioner. Yes, all right. Yes,
There is an appeal provision and there is a bar to file a suit
Where is that?
under Regulation 204. 204. 204. No suit or other proceedings shall under otherwise expressly provided in this regulation lie or be instituted in any civil court with respect to any matter arising under and provided for by this regulation. So under the regulation, there is a provision for appeal. So suit is filed.
What do you say? You are the plaintiff.
I am the plaintiff. Where my lord, what happened, the same argument was advanced earlier also before the trial court as well as before this one. What happened? My father occupied during settlement, my father occupied 4 hectares of land. That is 4 hectares. As per the settlement scheme, my father was entitled to get 2 hectares.
No, Mr. Pallar, why are you? How is the suit maintainable? Whatever point you may have,
Yes.
including fraud, go before the settlement commissioner.
No. Sir, there must be some order. No order has been passed. Nothing. Let me complete my submission. These are the land. This portion has been allocated because my father was entitled to get only 2 hectares, 2.02 hectares. This portion was allocated. This portion remained in possession of my father. At the time of settlement or allotment, there was no road. Now the administration constructed road this side, Blacktop Road. Now this portion which is under my occupation after death of my father, this is more valuable. Now what happened is 2007 the allotted land was sold by my father to the petitioner here. Now instead of taking possession of that land, because this excess land is more valuable because of that Blacktop Road, they in connivance with the settlement department prepared a new map. My lord, kindly come to the actual map. It is enclosed with page number
No. So a
50.
new map has been prepared by the settlement officer.
No, cannot be. No map.
Question is,
My lord, let me show the document. Page number 52 is the actual map which was sold by my father. 52. Running page 52.
yes,
Yes. The map is in L shape.
can't, impossible to
Next page
understand.
is legible. Next page is legible. 53.
Yes,
Yes. Map is L shape.
yes.
This landed property was purchased by the petitioner from my father in the year 2007. Now, they have not taken the possession of that land. That land is still remain vacant. Now, what he did, because the excess land, which is survey number is 1/P, it is more valuable than this purchased land. In connivance with the settlement department, map was corrected. My lord, kindly come to page number 58, the corrected map. 2 different maps.
Who
No.
corrected? Who corrected?
I don't know who corrected. No order was passed. Nothing was passed. The land is under my occupation. No order. My learned sister is arguing that there is a appellate provision. Section 28 of the regulation says if any order passed by the revenue officer, there is no order at all. Straightway map was corrected, and on the basis of this manufactured map, he is trying to take possession of that land which is under my occupation since in the year 1949 allocated by father. This is the case. The land which is the land which was purchased by the petitioner herein, that land is still vacant. But he is not taking possession. Even he found that as because since 2007 to till date, he is not taking possession over his purchased land. The adjacent plot have occupied certain portion of that land also. He is not taking any steps against him who occupied the land. But my case is that whatever you have purchased as per the map, the revenue map, you take possession. Why you are willing to take possession of the land which is under my occupation? Survey number 1/P has been corrected as to it.
What about 204?
204, if there is any order in that case,
No.
no order has been passed.
No. 204 does not talk of any order.
Let me.
It talks of any matter
Yes.
arising under the regulation.
Nothing was raised.
What? This is under the regulation.
No, no.
According
My
to
lord.
you, incorrectly, this map was corrected.
This map not corrected by the revenue officer. That is the case. Revenue officer, the Tahsil office. Tahsil office map, the original map is lying with the Tahsil office. That is the reason when on the basis of the demarcation, on the ground of demarcation, try to take possession over the land as per the corrected map. The Tahsildar refused. Tahsildar refused to demarcate the land because the Tahsildar is having set some other map, which is the actual map.
After research, this is
The map is in L shape,
Hmm.
but it has been corrected, which is appearing at page number 58.
kindly see, my lord, all officers have been filed. It is not have decided.
No, madam. No, madam. No, madam. I agree with Mr. Haldar. No.
77.
No, this is not a court of appeal. And no, yes, I'll see everything.
Provisional map.
First time same ground has been
Be-
taken before the trial court
That has it
rejected
been.
the application.
Provisional map was
Revision filed, the Honorable remanded back the matter, directing the trial court to frame a preliminary issue and decide the same.
no, my lord.
Preliminary issue has been framed by the landed trial court and thereafter decided the issue as there is no order passed by the settlement
Kindly
officer.
see the down,
Nothing.
down portion. The Tahsildar Faralgan has signed everyone. inspector
Either
has
what-
It is under challenge.
Whatever it be, go.
So
This,
he is having, he's a
I am in
mere encroacher.
opposition.
He is mere an encroacher. I am the
Maybe.
recorded tenant. I have purchased.
You
entire
recorded
land,
tenant.
defend the suit. Establish that.
purchased the land long
Will be
back.
decided
I am
in
not
the suit.
able to do
He has no problem if you take possession of the land that you have purchased, but he is saying you are trying to grab some other land.
By way of this,
Demarcation
no.
can be done.
by way of demarcation, he is trying to take position.
Go and tell the court below. This is not the suit court.
Yes.
May take this revisional application
Not to position.
has been filed challenging an order dated December 15, 2025, whereby the learned trial court rejected a preliminary point of non-maintainability of the suit raised by the defendant in the suit being the present petitioner.
They have to one document. How much land they have? They have filed earlier one saying, wherein they have stated they have only 2.02 acres.
Madam, these are all on merits. Go and argue them. We are only on jurisdiction with the bar.
In that case, Manoj, they have mentioned 2.02 acres.
Again, that's on merit. Go and argue that. Who stops you? What did I say? Non-maintainability of the suit raised by the defendant in the suit being the respondent, being the petitioner herein. Present petitioner. Stop. Paragraph. The opposite parties herein, opposite parties numbers 1A2, no,
E and 2.
1A to 1E
1E as well as
and 2 filed a suit being other suit number 79 of 2022 before the learned civil judge, senior division, South Andaman, Port Blair, praying for inter alia the following reliefs. Prayer A, B from page 45, running page 45. Paragraph. The defendant in the suit raised a point of raised the point that the suit is not maintainable in view of regulations. Which are the ones, madam, you said?
49A, Manoj.
49A.
Okay.
49A
and
28 1E
28(1)(e) small e and 204 of the, give the full name, Andaman Nicobar Island Land Regulations. Stop. That contention was, it was decided once against her,
Yes,
against the,
second time decided.
File the written statement, so maintenance point cannot be taken. On that ground, it was rejected earlier.
very well.
Subsequently, it was
Uh,
decided on.
that point was rejected, that contention was rejected by the learned trial court. Now, delete. The learned trial court refused to entertain such contention on the ground that the defendant had already filed written statements. Stop. Challenging such order of rejection of the contention of the defendant, comma, the defendant had approached this court earlier by way of a civil revisional application, stop, by an order dated. Where is that order? Where is that? By an order dated 153.
159 is the relevant date. You have 58.
159. Order dated September 4, 2025, comma. A learned judge of this court disposed of the application by directing the learned trial judge to frame a preliminary issue under Order 14, Rule 2 of the Code of Civil Procedure with regard to the maintainability of the suit, and dispose of the same as expeditiously as possible. Stop. Paragraph. Pursuant to such order, comma, the learned trial court heard the parties on the preliminary issue of maintainability of the suit, and by an order dated December 15, 2025, rejected the contention of the defendant and held the suit to be maintainable. The operative portion of the order reads as follows. Page 166, bracketed portion. Paragraph. It is this order that is assailed by the defendant in the suit by way of the present application. Paragraph. Learned advocate for the petitioner has drawn my attention to Regulation 49A, 28(1)(e) and 204 of the 1966 regulations, which read as follows, set out from here. Paragraph. Learned advocate has argued that in view of the aforesaid provisions, there is a bar to maintainability of the suit. Stop. The plaintiffs were at liberty to approach the settlement commissioner by way of an appeal as provided in the aforesaid regulations. Stop. Paragraph. On the contrary, learned advocate for the opposite parties of the plaintiffs has argued that the bar in the regulations does not operate. Stop. No order has been passed by the settlement officer which can be taken up by way of an appeal before the settlement commissioner or any other authority. Stop. The relevant sketch map has been illegally tampered with by the present petitioner. Stop. The officers of the land department have in no manner corrected the sketch map. Stop. The sketch map relied upon by the present petitioner is a manufactured and forged document. Stop. Hence, comma,
One more submission.
a declaration has been sought for in the suit that the concerned sketch map is null and void. Yes.
86 of regulation says that civil court is having jurisdiction to decide. 86.
86 of the regulation.
Regulation 86. The civil court shall have jurisdiction to decide any dispute to which the government is not a party or any right which is recorded in the report.
Yeah, government.
Government is not a party.
Yeah, government is not.
A party
Here,
Dispute is between,
is a private dispute,
dispute is between the
private parties.
86.
अभी पढ़िए सर अभी तो सामने था
Pro forma. Government is pro forma. In the suit, pro forma. No relief has been sought for against the government. Have you sought for any relief? Stop. Paragraph. Learned counsel for the opposite, private opposite parties also draws my attention to Regulation 86 of the 1966 regulations, which reads as follows. Set out 86. Paragraph. Relying on Regulation 86, Learned Counsel submits that the civil court has jurisdiction to decide the suit filed by his clients. Stop. Although government officers are parties eo nomine, comma, they are pro forma defendants and no relief has been sought for against them. Paragraph. Having considered the rival contentions of the parties, comma, I am of the view that there is some substance in the contention advanced by learned advocate for the opposite parties oblique plaintiffs. Stop. Rule 86, Regulation 86, clearly reserves the right to civil courts to decide any dispute to which the government is not a party. Stop. Stop now, comma. Relating to any right which is recorded in the record of rights. Stop. Relating is a very wide word, madam. Relating is a very wide word. Stop. In the present case, comma, the government is not a party to the dispute between the petitioner and the opposite parties oblique plaintiffs. Stop. No relief has been claimed against the government. Stop. The dispute between the parties also in a way pertains to a right which is recorded in the record of rights. Stop. Stop. The word relating to inverted comma is of very wide amplitude. Stop. Paragraph. I am unable to agree with the contention of learned advocate for the petitioner that regulations 49A, 28, 1E and 204 operate to bar the suit filed by the opposite parties, oblique plaintiffs. Stop. The relief claimed by the plaintiffs in the suit perhaps cannot be granted by the settlement commissioner. Can he declare it to be null and void?
Yes.
Settlement
My
commission.
clear is to declare it null.
Settlement commission.
No,
Stop. I do not find any such glaring illegality or procedural impropriety in the order under revision as would persuade me to interfere. Stop. One must keep in mind that while exercising the supervisory jurisdiction under Article 227 of the Constitution of India, the High Court does not act as an appellate authority. Stop. The High Court will be justified. No, the High Court does not correct mere errors of law or errors of fact in the order impugned. Stop. Only when the order of the tribunal or subordinate court is wholly illegal or perverse or beyond jurisdiction or without jurisdiction or where manifest injustice will be caused to a party if the High Court does not interfere, the High Court exercises its jurisdiction under Article 227. Stop. It is settled law that such jurisdiction has to be exercised sparingly and cautiously. Stop. Paragraph. In the present case, I do not find that the petitioner has made out a case for exercise of this court's jurisdiction under Article 227 of the Constitution of India. Stop. I make it clear that I have not touched the merits of the case otherwise. Stop. The petitioner will be at liberty to urge all points on the merits of the case before the learned trial court. Paragraph. CO subsidy accordingly disposed of. Once you recommend.
Item 2, WP 30/2026.
Yes. What is your instruction? Why is not important?
But you know, the application itself is invalid because illegal diversion, there's a case of illegal diversion. And time and again, there was, they have called for report enrollment. And for that reason, I have not the entire thing about what action they were taking. Because of.
Madam, you are not addressing the real point. It's a point of law. No, I have not asked you why the delay. That is not the question. I am not interested to know why the delay. Admittedly, there is a delay. Once 4 months expires, there is deemed permission. So, proviso is not a part of the regulation. Very much so.
Because there is a case of illegal diversion. And for that, they were asked to produce certain documents also. I have,
No, then you do this. You file an affidavit.
Come to the order passed by.
You come to that,
earlier
but
court, ma'am.
no, madam, let her file an affidavit. Yeah, let her file an affidavit.
Court, madam. That order is there. If it is vacant, their permission has to be given. It is there, madam.
The entire land. She has.
No, madam. In the same way, as well as the earlier court, I have said, the vacant land of 102 is.
Madam, please understand, you have approached a court of equity. This is the writ court, right? And she is taking a point of illegal diversion. I want her to put that on record. That is all. Where? Which page?
Page number 22. The order start. Lecture P2.
Annexure?
P2. Because earlier, my lord, earlier in this silent manner, prior to taking of the sale permission, my lord, one has to take the notice, non-encumbrance certificate and valuation certificate. Then to apply before the Deputy Commissioner for sale permission. That provision, that mandatory, that document has been now removed. But prior to that, this was the suggestion. And my application earlier was on that ground, it was rejected. And this Honorable Court has found that it is a vacant land. If it is a vacant land, you have to register. That is their color. It is a vacant land.
But
And it's square
it's
meter.
the application that has been filed for obtaining the state permission, it was entire land property law. They're not asking for the 100 square meters, which is land vacant. They're asking for the entire land where the commercial activities is going on.
Para 16 is very clear.
They're carrying
In
out
that
the
order.
commercial activities.
Para 16.
You have found diversion.
Not in that, not in this land. Kindly see, my lord.
How
It will
do,
be para 16.
how do we know, madam? Do we have those documents before? Do I have those before me? Hey, come.
Vacant land of 150 square meter.
They're asking for the entire land. Commercial activities is going on.
Read order dated January 29, 2026. Stop, paragraph. Today, learned advocate for the respondents says that her clients would like to file an affidavit to bring on record certain relevant documents which would show that the petitioner has illegally diverted the usage of the land in question. Stop. Therefore, he cannot be granted permission to sell the land unless such illegal diversion is regularized. Stop. Paragraph. Although I had recorded no. Next. Let affidavit in opposition be filed by the respondents within a week from date. Stop. You want to file a reply? Reply thereto, comma, be filed. When?
3 days.
3 days. Then it will be next circuit. Within 3 days thereafter. Paragraph. If you can file by Monday, by next Friday, if you file your opposition, by Monday, if you file, I can keep it on Tuesday. That's the last day. Or you want it for the next circuit? Better. The reply there to be filed, if any, be filed within 3 days thereafter. Paragraph. List the matter before the next available circuit bench, subject to its convenience.
Friday, madam.
No problem.
Item number 3. WPL
Lord, I was end up in principal rooms, you know.
So, was your client sent to jail?
It has been dropped, you know. Contempt, bro, not really. I'm extremely sorry, bro. Due to my mistake.
No problem.
Lord, here I have challenge and award passed by the labor.
Yes, your application was dismissed.
The case is that.
Appeal has to be heard,
Yes, madam. Yes, madam.
filed informal paper book, or all papers are here.
LCR may be called for, normally.
LCR.
Yes, LCR is called for, all the document I have enclosed, but LCR. Suppose.
The labor court, comma, A and N Islands has decided a reference made under section 10(1), say 10(2)A, 10(1) of the Industrial Disputes Act, comma, against the present writ petitioners. Stop. Paragraph, learned counsel for the petitioners fairly says, petitioner, make it the petitioner, one, precedent, fairly says that the appeal, the writ petition has to be, you don't want to file any affidavit, do you?
No, my
No,
lord.
madam.
This is.
Because it is the proceedings of the,
Has to be heard out after transmission of trial court records to this court. Paragraph, let the department call for trial court records and ensure that such records are placed before this court on the next date. When should we keep it?
Any date, my lord.
No, how long will it take?
What,
The
1 week?
1 week. Next Friday? List the matter on next Friday. Give the date.
Item 4. Flow, 55,125. In item.
Yes, what is your instruction? You are prepared to go for mediation.
Mediation.
What is your instruction? We only want that bit. What is your instruction, sir? Whether your clients are agreeable to go for mediation or not. That is why these matters have appeared today. You can't tell us that.
That's for me to take.
Pass over. Please inform him.
Yeah. Question. Item. 48.
Mr. Khan, as soon as Mr. Shamuntu comes, please draw that to my attention. I'll take it up. 14.
55425.
I'm appearing for official respondent, my lord.
No, I am.
Great.
Yes, Mr. Vinupur.
Hello. Lord, here, the restaurant number 1 is a minority school. Now, my lord, minority school, my lord, under Article 3 of the Constitution of India, they have power to administer other schools. Now, my lord, the basic requirement which a minority school at the time of assumption in service has to consider is that the recruitment rule of a minority school, so far as minimum qualification is concerned, ought to be at par with the state school, state recruitment rule. Whatever recruitment, suppose a teacher or a peon or whatever post they are appointing, the minimum qualification ought to be same. Essential qualification may differ, but minimum qualification that ought to be same. Now, my lord, in this case, my lord, the post of postgraduate teacher biology was published. Initially, publication was made. On the basis of publication, I participated. A selection committee consisting of the
members of the said school and the state authority, that is the education department, were a party in the said selection process. Once the selection process was culminated, I stood at serial number 4 because serial number 1. My lord, it is based on assessment on the basis of our marks from 10, 12, college level assessment. My lord, so far as minimum qualification is concerned, it is at par with. Now, when this selection process was culminated and I was found at serial number 1, my lord, it was sent to the state authority for the purpose of approval. Since, my lord, 95% of the aid is being provided by the government. So therefore it was sent. When it was sent, they say that since at the time of inception of the proceeding, you have not taken the approval of the education department, it cannot be done. Now, my lord, I am armed with authority which says that so far as approval is not at all required. Now, despite of that, the school authority, my lord, what they have done, my lord, they have stopped that process, rather cancelled that process. Once again, they initiated the process of recruitment on the basis of the approval accorded by the administration. So, administration has accorded approval. Once again, I have applied for it. When once again I applied, same selection process was conducted. The authority from administration was a party and selection culminated. And I was found to be the most successful merit. I stood at serial number 1. Now, when it was sent for approval, this time they say that you have put a column of demo classes, which cannot be in terms of a notification of Government of India, which says that the interview process is no more required so far as Group B posts are concerned.
D.
Group B.
B.
Group B non-vested posts are concerned. Interview process is not required. Now, my lord, first of all, taking a demo class is not an interview. Secondly, the office memorandum of Government of India are not applicable to the minorities. There are authorities on that. So, my lord, on both the code, they did not have any right or any access to interfere on this code. The only requirement is they have to see as to whether the minimum qualification criteria in the recruitment rule is fulfilled by the school or not. Now, my lord, I will place,
So which order is under challenge?
my lord. Page 52, my lord. Paragraph number 2.
Yes.
Now I have taken, my lord, that similarly circumstances, selection process of postgraduate teacher in mathematics and all, there they have approved and given appointment to the same school. So what they want to say so far as only with regard to postgraduate teacher biology. Why? Because, my lord, I have enclosed that document also whereby they have accorded the sanction. Now, my lord, may once see that.
No, but tell me one more thing before you proceed. Which instruction you have not complied with? That also this order does not say.
No, they say, before that there is one order, they say that, my lord, I'm just placing that.
No, it is the recruitment rule, my lord. They have framed the recruitment rule in deviation to the recruitment rule of the state government.
No, no, paragraph 2 of that order under challenge, page 52. If you look at paragraph 2, minority aided school is bound to comply with instructions of the government of India.
Page 42. Page 41, start. This is the first communication where they said it cannot be done. The school made a representation saying that you don't have the pharmacy control or the school. And, my lord, relevant page is page 44, last second paragraph. I'm sorry, I'll just read you.
Right.
Paramount ground was this, which they have taken. Now, my lord, in their affidavit in opposition, I will show, my lord, 2, 3 paragraphs whereby they also say the same thing. If my lord comes to page 20, paragraph number 55 of their opposition.
Yes.
Now, my lord, can you see their stand? Para 55, they say it is well settled that the right guaranteed under Article 31 of the Constitution, though fundamental in character, is not absolute. Minority Educational Institute enjoys autonomy in administration, including selection of staff, subject to the condition that such appointment conform to minimum qualification and eligibility norms prescribed by the competent statutory authority. Any interpretation that treats Article 30 as a character for exemption from statutory qualification norms is constitutionally impermissible. So practically, my lord, only minimum qualification is what required. Otherwise, my lord, there is no requirement. Assuming, my lord, may visualize the situation. There is a recruitment rule of the state authority saying that this would be the minimum qualification. And at the same time, we are also saying this would be the minimum qualification. Apart from that minimum qualification, if we ask for something and if it is denied, then in that case, there is no requirement to have 2 recruitment rule notified under Article 309. It ought to be, my lord, mutandis, that would be applicable, my lord. Why a separate recruitment rule? Then the very purpose to have a separate recruitment rule is that we must have our autonomy, but there would be no compromise so far as minimum qualification is concerned. That's why otherwise one recruitment rule will do. Now, my lord, may kindly see page number 24 of their reply. Paragraph number 83, my lord. Are partly admitted to the extent settled by the Supreme Court. Now, next page, my lord. It is their opposition wherein they say so. They say that minority institutions have autonomy in selection subject to minimum qualification prescribed by the state.
Yes.
So this is the requirement. Now, my lord, one more paragraph at page 16, para 42. Says the Honorable Supreme Court in so and so has clearly held that once the eligibility condition and minimum, this they are wrong, is that minimum qualification prescribed by the state or the competent regulatory authority are fulfilled, a minority educational institution retain full autonomy to appoint teacher, lecturer, headmaster, and principal through a rational and fair procedures of its choice. The court further observed that during the
Here there is no dispute that the minimum qualification is.
There also, my lord, in 2 paragraphs they have said so. In letter it was not in my lord, I will show page number 7, paragraph number 21. Para 21, my lord. The essential qualifications and recruitment rule for the post of postgraduate diploma is not similar to the recruitment rule for the post notified in the so and so. Furthermore, the essential qualifications stipulated in the vacancy notice is not in consonance with the recruitment rule. The needless to conduct demo classes for recruitment to the post equivalent to so and so, this has been discontinued. My lord,
So these government instructions may not apply to.
no, my lord, I have judgment clearly says.
But what about the first point?
First point, my lord, first point is they say that it's not similar to the recruitment rule. Similarity is not the requirement. Minimum qualification is the requirement.
It's a question of fact.
Yes.
Show me that
Yes.
this say minimum qualification is the same. It's not
Not-
less than what the state has prescribed.
My lord, I have produced, I can show the recruitment rule also, and I have introduced it in my affidavit in reply. My lord will get it in page number 3. Starts from page number 3.
With the opposition.
Affidavit in reply, my lord, to the opposition by the respondent.
Yes,
Page number 3, my lord.
yes.
Para number 7, my lord.
Hmm.
But the above meeting so and so, so and so. It is to submit that only requirement is the minimum educational qualification to the post of postgraduate teacher biology under the response number 1 and the school under the response number 2 are one and the same. The detail of the requisition. My lord, first one is the minority school, my lord. Master degree, my lord, you can compare it, my lord, with master degree from a recognized university or its equivalent with at least 50 marks in botany, biology, zoology as the main subject and in aggregate. Now, my lord, their recruitment rule says bachelor, master degree from a recognized university in this subject concerned. Now, my lord will find our is higher.
Stricter, correct.
Yes. Now, second, my lord, bachelor degree in education get from a recognized university by so and so. Bachelor degree in education from a recognized university. That is should have studied botany, biology, zoology subject both undergraduate and postgraduate. They say should have studied the concerned subject as main subject both in undergraduate and postgraduate. Should have studied in English medium up to the degree level. Hindi medium condition may be considered if their command over the English language is exceptionally good. Now, my lord, here we have enhanced it. Should have studied in English medium up to degree level. In they say should have studied in the concerned medium.
Higher.
Higher. So, my lord, so, my lord, the minimum qualification which is there that we fulfill, my lord. Now, my lord, I will show there is a case of discrimination also. Apart from this post of PGT biology,
Mathematics, you said so.
mathematics and 2-3 posts, my lord, I will enclose those documents, which at the similar point of time, those publications were made at some interval, those they have accepted. So, it sounds of something else, my lord. Why only this PGT biology? Now, my lord, may kindly see on both the occasion. Now, my lord, so far as demo class is concerned, my lord, this is only an exercise to get an exceptionally good person for the said post. So, if
Just show me that the government notifications don't apply to minorities.
my lord, I have 2 judgments, my lord. I am just placing this judgment. Even Delhi High Court judgments are there. My lord, this is 2010. I will just hand over, my lord. All the judgments are bulky judgments, my lord. My lord, I am just reading the classical. It says Constitution of India, Article 30, 29 to 60, so and so. Status and nature of autonomy of aided minority school. Expression: a service under the state in Article 16 ambit. Employment in minority school, aided or unaided health, cannot be construed as a service under the state under Article 16, even with aid of Article 12. Merely receiving granting aid per se would not make such school or institute state within the meaning of Article 12. Therefore, the rule under so and so of the Delhi so and so rules 1973 and circular of September 1989 not enforceable against the linguistic minority school of NCT of Delhi. My lord, this is 2010 judgment, my lord. Now the only requirement.
This is Supreme Court.
Supreme Court, my lord. Even there are several High Court. I don't want to bother, my lord. Even this approval portion, my lord, I have armed with one Delhi High Court, which says no requirement of prior approval for making a paper publication. In earlier recruitment process on the said score, and the school also conceded to it because they are getting granting aid, they don't want to go for it as well.
Yes.
Now, my lord, earlier also this issue of non-payment of this 95% was cropped up before this court matter travel up to Supreme Court. And the court said, no, you have to pay. And they are paying after unsuccessful before all the group. With regard to this Nirmala school and one more aided school is there. Now, my lord, may kindly see my position, my lord, how I am at serial number 1. Even if demo class is not considered, my academic assessment, I stood at serial number 1. I am just placing it, my lord.
No, I'm accepting what you are saying.
My lord.
Let me hear him. Mr. Sivabalan.
My lord, this writ petition is completely misconceived, my lord. They have challenged the order dated 16th September 2025, whereas my learned friend has shown some other letter. The order dated 16th September 2025 is annexed at page
Page
number.
52. Page
42 and
My lord. No, the
52.
impugned order, my lord, it is at, in my reply, page number 104. Dated 16th September, my lord, annexure R15, 50. Only this
Pi-
letter has been changed.
Page 52, yes.
My lord, the second paragraph may be seen, my lord, the essential qualification in RR of minority aided school has to be in line with the RR of the Director of Education. The school has affirmed and informed that the RR contains all essential qualifications at par with the Director of Education. This has not been complied in this instant case. This is the objection, my lord. And
This objection is baseless.
no, my lord, but currently see, they have RR may be seen, my lord, both the RR.
He has set out the RRs in his affidavit in reply.
My lord, this
Unless you say it has been wrongly set out.
Yes, my lord, this RR has deprived the person, candidates who have studied up to class 10th. Those candidates have been deprived in this RR by the school, whereas in the RR of the education department, they have been allowed. That is a matrix, your honor, that your lordship, that RR has deprived the candidate who have studied up to class 10th.
No, the minimum qualification should be the same.
No, no, the class 10th, those who are students, those candidates who have studied up to class 10th, they cannot apply in the as per the RR of the school. Whereas as per the RR of the department,
Post is
postgraduate teacher.
somebody who has read up to class 10 will apply for the post of postgraduate teacher. What are you saying?
My lord, this,
bar, there is no.
my lord,
No.
the thing is there, my lord.
Are you following what you are saying?
No, my lord, there is.
What you are saying is that somebody who has read up to class 10 may apply for a postgraduate post.
No, but that RR may be seen, my lord. That is the difference. The RR, one second. Annexure R12, 84.
It is there.
Mr.
My lord.
Bindu Kumar, I have followed your case fully. One page note, only point wise.
Hello.
Number one, the earlier round,
Yes,
because before initiation approval was not taken, therefore.
yes,
Then with approval initiation,
yes,
this round.
yes.
And ground is the minimum qualification is not same and demo.
Did not follow the instruction of the government of.
Third, discrimination point include,
Discrimination, yes, madam.
right? Fourth, only the case law.
Yes.
One page note.
My lord,
You go
one
through
second,
it,
my lord, come.
Mr. Sivavalan,
My
go
lord.
through it. Come back on Monday,
My lord.
because now you are looking through the paper.
My lord, one second, my lord. The qualification is that those who have studied in the concerned medium up to secondary level. It is regarding concerned medium up to secondary. Those who have studied in the concerned medium up to secondary level, they have been deprived, my lord. Graduation is there, my lord. BEd graduation qualification is there. But those who have studied.
Please understand one thing. They are entitled to have a higher qualification, call for a higher qualification, not lower than what you say. That is what essential means, minimum means. You want time, take time, Mr. Sivavalan. Come back on Monday with the one-page note. And please, only 5 to 7 minutes I will hear you. Point out the documents. No point, I can take up some other matter now.
My lord, regarding prayer approval, my lord, they themselves have considered and they have sought for approval. Now they cannot come back and say that approval is not necessary.
What can they do? What can they do?
They cannot take that.
You will even stop the grant. You will stop the grant.
No, my lord, they are aided school, they have to follow the rule.
They have to do your dictates, however stupid those dictates are.
No, only recruitment rule they have to follow, madam. We are not telling that they cannot appoint.
please look at paragraph 3 or 4 of the affidavit in reply. He
Madam.
has set out the recruitment rules of your client
Madam.
as also of the school. Consider them, come back. Hey, come, Stephen.
That selection process, their person is also present in the selection process.
But no right of voting, no mark is given. There's only,
I've heard learned counsel for the parties at length. Stop. Paragraph, an order passed by the concerned authority refusing to grant approval to a list of successful candidates prepared pursuant to a recruitment process for filling up the vacancy in the post of postgraduate teacher in biology in the respondent number 1 school, comma, is under challenge in this writ petition. Paragraph. Learned counsel for the writ petitioner has argued primarily that the grounds on which the approval has been withheld are illegal. Stop. Firstly, comma, the minimum educational requirement prescribed by the recruitment rules of the school in question are in fact higher than what the government recruitment rules prescribe, and therefore on that ground and considering that the school is a minority school, comma, the approval could not have been withheld. Stop. In this connection, learned counsel has referred to Article 30 of the Constitution of India and certain case laws. Stop. Paragraph secondly, comma, the ground that since the recruitment rules of the school contemplate a demonstration, what is it?
Demo classes.
They contemplate demo classes, which is at variance with government instructions, comma, is also not tenable. Stop. Government instructions are not applicable to minority schools. Stop. Paragraph. Mr. Sivabalan, learned counsel representing the respondent number 2 has made his submission. Stop. He seeks a little time to come back with better instructions. Paragraph lists the matter as the number 1 hearing matter, as the first hearing matter. Monday, though, date, give the date. I'm not seeing short notes, but just 1 page note you can both file.
Madam. Madam, judgment we have also enclosed.
Oh, yes. Another point urged by, give that before. Another point urged by the counsel for the petitioner is that in similar circumstances, comma, approval has been granted by the government for the list of candidates forwarded to it for filling up other posts, other postgraduate posts in the same school, including mathematics, English, and
GTT mathematics also.
and GTT mathematics. What are you saying?
My lord, we have enclosed the judgments, my lord, from R22 to R27.
Yes.
That any violation appointment is violating to the recruitment rule of the state.
Sir,
That-
those judgments will be fine, but
My lord.
where is the violation you have to show me? You have to factually show the violation. Next, well,
Oblige, my lord.
Between Shiana and the state. For the petitioner. Appellant,
yes,
the limitation is there. Delay is there.
the limitation has to be,
Notices to be issued.
yes, and then that delay has to go before this. Oh, I'm a single judge now.
Yes.
Forgotten that. Yes, very well. Can 1, recorded order in Can 1. This is an application for condonation of delay in presenting a second appeal. Stop. Let notice, let service be effected on the
So respond.
respondent and affidavit of service be filed in court on the next date. When? Tell me when? Next circuit. Paragraph as suggested by the, by learned, as suggested by learned counsel for the petitioner, comma, list this matter before the next available.
I'm praying for all for the LCR.
Hmm?
All for the LCR.
Even before admitting the appeal.
Should be admitted, because the advocate, the appellant engaged the advocate. Advocate failed to appear. The learned court will have decided the case on merits.
You are not following, Mr. Prashant. Today there is no appeal. In what will I pass an order? Today in the eye of law, there is no appeal.
At the time of filing the appeal, I filed only the judgment.
Yes.
Degree was not filed. Now I got the degree. So I will undertake to file supplementary evidence to include some.
That you file. That's right. Before the next circuit, subject to its convenience, stop, paragraph. Leave is also granted to the petitioner to file a supplementary affidavit to bring on record certified copy of the decree in question.
Alright. Item number.
Lordship, I am appearing for the petitioner, Lordship.
What is this?
I filed 2 CAN application, Lordship. First CAN application is for restoration of writ petition. CAN 2 is section 5 of limitation, Lordship.
Appearing. File is affidavit of opposition.
Yes, yes, of course. 15 days delay.
15 days.
15 days delay. দাদা কিছু লাগবে না আমার খালি রেজিস্ট্রেশন দাও ক্যান আচ্ছা ক্যান 1 ক্যান 2 টা দাও এটা ক্যান 1 আর ক্যান 2 টা দাও When was it dismissed?
Was
I see. 31st October.
31st October.
No. First take CAN 2. This is an application for condonation of delay of 15 days in filing an application for restoration of the writ petition which was dismissed for default on October 31, 2025. Stop. Paragraph. Causes shown being sufficient, the delay is condoned. Paragraph. CAN 1. Sorry. CAN 2, I think. Kunta delay ta kunta baba?
CAN 2.
Sorry, it CAN 2. First CAN 2. CAN 2 is disposed of. Next take CAN 1. This is an application for restoration of WPA 388 of 2025, which was dismissed for default on October 31, 2025. Paragraph. Having heard learned counsel for the party, will his presence be recorded?
Its file is updated in opposition.
So record his presence also, Mr. Having heard learned counsel for the parties, I am satisfied with the explanation furnished for absence of learned advocate for the writ petitioner on the day.
On that day, petitioner appeared in person. On the last occasion.
Which occasion? 31st October.
1st October.
31st
October.
Who appeared?
None appeared, Your Honor.
I am on the क्या बोला? for absence of learned advocate for the petitioner on the day the writ petition was dismissed for default. Paragraph, accordingly, the order dated October 31, 2025 is recalled. Stop, WP number such and such is restored to its original file and number. Paragraph, can 1 is disposed of. Paragraph, list the writ petition when?
Next week, my lord.
On Tuesday? Tuesday, give the date.
He appeared in person.
In
He was
person.
not appeared on that day, as Lord said, the advocate was not,
Hmm.
petitioner was not.
Not appeared. Initially, when writ petition was
So
filed,
that's-
he
Oh, I
he
see.
appeared in
Oh, I
person.
Then just say, having heard learned counsel for the parties, I am satisfied with the explanation furnished for the absence of the petitioner,
Petitioner.
comma, who was appearing in person, who was earlier appearing in person. Huh? Comma, who was earlier appearing in person, comma, when? Ah,
Obliged.
Okay, for the first year, this is the same matter where the petitioner.
yes, bank,
My seniors appear for the bank, respondent one.
yes. So, you are here. You should hold the brief for your senior. Good opportunity to argue. Tell us what right a nominee has.
As per my senior suggestions, my lord, my humble submission to, as per the nominee, necessary order may be passed.
You are for the
I will
nominee.
respond. Nominee.
The money doesn't belong to you, sir.
Lord.
Is there a written rejection?
No.
Nothing. The grievance?
Lordship, may I place the case, my lordship, because I have other contentions. May I place lordship?
Are you saying that the money belongs to you?
Lordship, there is a contention that the money which is lying in the bank account that has been given in my favor by the way of hiba. Hiba nama, because the petitioner and the added respondent and the amount, the owner of the amount are Muslim by religion, and hiba is a practice in the Muslim, by way of which the said amount was given to me. So this is
Okay,
my contention.
No, that hiba nama, the bank cannot take that into consideration.
My lord, what my contention is.
File a suit, recover
Lordship.
it from her. That liberty I'll give you.
Lordship, my specific contention is.
Yes.
The subject matter here is in whom favor the amount which is lying in the bank account that should be released.
Yes.
My lord, I am harping upon the section 45ZA of Banking Regulation Act, my lord. The section very categorically says that unless and until nomination has been revoked by the depositor, that amount should be given in favor of the nominee, my lord. It is not disputed by the petitioner that I am not a nominee.
Very well. Then what I'll direct is, let the bank make over the money to you, and you will make over the money to her. Simple. Then go and file a suit. Say that this money was gifted to you by whatever hiba.
By the way of nominee, it may be released in my favor. As they are claiming their ownership, they may approach the
ownership. Succession certificate, legal heir. 45 Z.
Yes, my lord. On the basis of that, they can approach the appropriate forum for
You approach 45 Z. A.
45 ZA. Subsection 2, my lord.
Have you seen this? ZA2, 45 ZA2.
Immediately after his demise. If the bank has released it, then I had an opportunity to seek relief from him. But bank has not done. They have asked me to go and get the succession certificate. Till then, he holded the money. Now I have brought the succession certificate. There is a judgment of Justice A.S. Oka, Your Lordship may kindly see. A similar situation arose, and the Honorable Court was of the opinion that when a succession certificate has been produced, then the bank is released from the liability. Your Lordship, paragraph
Was there,
8 says,
in this case, was there a nominee?
yes, there was a nominee. Your Lordship, I'm just harping on paragraph 8. Respondent number 1 called upon the petitioner to produce a succession certificate to facilitate the speedy disposal of his claim. We find no error in the approach adopted by the bank when it insisted on the petitioner producing a succession certificate. This will enable the bank to obtain a valid discharge. We may, however, hold that on production of succession certificate under section 370 of Succession Act issued by competent court to the petitioner, the respondent banks will have to release the petitioner the amount standing to the credit of the accounts held by deceased so and so without insisting upon complying with other formalities such as production of indemnity bond, consent of natural legal heirs. The reason is that if the bank pays the amount to the petitioner on production of the succession certificate issued by the competent court, the bank will get a valid discharge. This question would have there your Lordship immediately after the demise.
Where was the nominee in this case?
Lord,
There was
I
no
believe the
nominee in this.
respondent itself would be the nominee in this case.
You said yes. When I asked you, you said yes.
The legal heir itself is a nominee in this case, Lord.
Consider 45, it's not that easy. Yes, ZA2. The bank has appeared today through learned advocate. Stop, it has been submitted that appropriate orders may be passed protecting the interest of the bank. Paragraph. Learned advocate for the added respondent relies on section 45 ZA, capital Z, capital A, of the
Banking
Banking Regulation Act, 1949, and says that the bank is bound to make over the money in the concerned bank account to the added respondent who is admittedly a nominee named by the deceased depositor. Stop. Section 45 ZA bracket 2 of the Banking Regulation Act reads as follows, Stephen. Paragraph. Learned advocate for the petitioner seeks a day's accommodation to come back with better instructions. Paragraph lists the matter once again on Monday. Monday, no, date, give the date.
Item number 18, Calcutta 304 of 795.
In this matter,
18.
Here the authority has been directed to produce the relevant reports. In that case, allotment was done in the year 1960.
2.02 hectares.
Yes.
Who was appearing?
GP.
Miss Das. Yes, I remember. What to do? Pass over? I am sitting till 1:15 today.
Item 19, WPA 345 of 725.
Mr. Rat now similar organs, now this might not the artificial and will not clearly know. They automatic appear on Monday.
Lord, as Honorable Court number 2 has released, we got few matters about that court number 2. Lordship was released as Lordship was fixed this matter for hearing. So these are all interconnected matters, not around 35 to 40 matters.
Same point it
Same
was.
point of law is involved, whether we raised that the point that it should be reached to the tribunal, appellate authority tribunal is there. They say that.
So ওইগুলো সব একসাথে list করে দাও। Monday, list all the matters, one after the other, along with 19. 19 to? 19 to 41. Very well, and then add the other matters that she has given. Hey, শোনো এ,
But even I also filed short notes as my lord. I filed it already on record. I
No,
check
no.
the record.
Bring it.
Yes, yes. Already filed it. I already filed, my lord. If required, I can bring one second so that.
If it is there, check the records. If it is there, then
The last occasion. What? I will.
short means short.
It's only the law point. That's because the question of law point whether it is to the trial.
Now an alternative forum is available,
Yes.
district judge, no?
Yes. But the regulation was created 2017. The rules for penalty has been created 2020. Based on the rules, because it's a self-assessment of VAT, they have to assess self. But 2020, the regulation has rules have come. So in the rules, the regulation, there is a provision that once an order was passed by the VAT authority, joint commissioner, then they have to approach before the appellate authority. Earlier, appellate authority was not there. Subsequently, it was with the correspondence with the Chief Justice of our Calcutta High Court, and he has given approval saying that the joint civil judge senior division would be as an appellate authority in terms of the regulation. After that, the Honorable Lieutenant has notified. So now, this is what if they have.
And all these writ petitions were filed after designation of this.
Few writ petition was filed after the designation of the court. Few was filed prior to that.
But if you satisfy me, I'll send
Yes,
all of them there.
But the only aspect is because they want to save the money because the tribunal says.
Pre-deposit.
Yes. That is the only good.
All right.
Yes.
Item 42, WPF 6 of 124.
My lord, in this matter, I am appearing for the private respondent. Official.
Official respondent?
Mr. Sivabala.
Your grievance is really against the official
Official
respondent?
respondent.
Then see if you can bring him. What can we do? What can I do? He was here. Pass it over or what? Not today.
Monday.
Item 43, WPF 720 of 124.
Pass over.
Item 44, SS 6 of 25.
For the appellant. Put for a specific performance. Only on the ground that he was the recorded, he was the title holder of the property. He failed to mutate the property in his name. That's why my specific performance was refused. Appeal court affirmed that. But issue claimed by this court while admitting appeal for that he is having the title. The any records does not anything.
You are the vendor or purchaser?
The purchaser. Deliberately he is not mutating the property in his name. So sale registered through the court in his favor.
I
It
see.
is registered in my favor. Why the amount will be returned to the.
Correct. Mutation is not ownership.
Yes. Title deed is there in his favor.
Who is on your other side?
Sivabala.
It's very difficult, Mr. Khan. Tell me what I should do.
It will be on Tuesday or Monday.
Let it be on Tuesday. Monday there are,
Very short matter.
yes. cite those few judgments that
Yes.
mutation doesn't decide title.
1961, there are series of judgment on this. I will come back.
Learned advocate for the respondent is not present. Stop. A very short point is involved in the second appeal. Stop. Paragraph. As suggested by Mr. Khan, learned advocate for the appellant, list this matter on Tuesday, give Tuesday, amongst the first 5 hearing items.
Item 45, Dr. P. 325.
Oh, Jesus. No private respondent?
Okay. Here, the petitioner. The petitioner to enclose the land prior to 1970.
78.
1978, as per the scheme of 1978, he was entitled for that. Like, here, my lord, as per the scheme, her name was recorded in the High Court Committee, and thereafter, my lord, license was also given in the year 1990. She has paid conservancy bill also till 1990. Thereafter, my lord, in the license it is mentioned, the premium has to be notified by the authority. That was not done. In the year 2011, first representation was given by the petitioner to the authority by saying that to notify the premium, how much premium it should pay. Thereafter, again, the notice was issued by the authority in the year 2013. Field inspection was done.
But all along you are in possession.
I'm in possession. Still I'm in possession. 2013 notice was given, field inspection was done. Thereafter, again 2014, I have given another representation by saying the same thing to notify me the premium. In the meantime, in the year 2015, on 28/4/2015, a press note was released, wherein it has stated, whoever having the license not paid the premium, certain conditions were paid, if it is fulfilled, to pay the premium. On the basis of that press notification, I have again, because at this particular time I was not there, so in the year 2018, again representation given, because I have been left out with the premium, acceptance of premium, my premium may be accepted. Thereafter, again 2024 was the representation given. Nothing happened. Thereafter, she has approached before this honorable court with a direction to consider my representation within certain time frame. Thereafter, further notices were given. One fine day, that is on 3/5/2025, the order was passed by the Deputy Commissioner rejecting my application, challenging that I have come. Third, I show the entire document. Annexure P1. Annexure P1 is the scheme.
Why don't I ask her what is lacking? Why shouldn't?
Well, they have.
So, at during that time, the license, the land, they were asked for some of the documents for and the exhibit. And the second condition, what are the conditions? The licensee is still in possession of land. The licensee is willing to vacate the standing pending. Licensing has not the scope of the rate of the licensee, they need to inform the. The license was in respect of serving about 23/3 by 15. And for that particular land, she was not found in possession. She was never in possession of that particular one. Subsequently, she has the position. When they were asked for acceptance of the payment, she was not in possession. So first.
And license would be granted only after premium is paid, is it?
No.
No.
But license.
license of license also, there are creating like the including with the structure. You have to utilize that for what purpose you have been given the license. But she has never utilized the license, only the license is given. And in the year 2015 also she came to represent documents that she is still in possession. And there is communication of facts, whether she was in possession after getting that license or not.
We are concerned with survey number 23/23/3. She was found not in possession in 2015. You have said so on affidavit.
Page 7 of my constitution. And
Yes. Yes. Then this is the position.
I will show only 2-3 documents which
they
they have.
have to be provision because even in the license also, there is within 2 years you have occupy that particular land and you have to utilize that particular land on the, as per the license for utilization purpose for which the license was issued, but that was never utilized.
Where is this impugned order?
Hello, I'll show only the documents wherein it is stated that I am in possession. Their own documents. I have annexed license. That I will. My lord, the license they have given prior to giving of the license, my lord, the high power committee survey was done.
Page 49, it starts with page 49.
46.
46, page 46.
Yes. Yes, show me those documents.
My lord, here, first document at page 23.
Page 20.
23.
Yes.
Page 23, wherein this is the high power committee, where my name has been recommended. It's at page 24. Serial number 4, my name is recommended.
Recommended for what?
For regularization of the land. My lord, thereafter, the license was issued at page 26. It's at page 26, and it's P3. As per this high power committee recommendation, license was issued on 21st of December 1988. I,
26. Yes.
when she submitted, I think.
For one, it's very clear the license, she shall transmit the house in the said land.
Yes. All right.
This is the license, which was issued on 21st day of December 1988.
You have a house there.
See, at present I don't have. Because, my lord, it was constructed prior to 1978. Then what happened? Kindly see the next page, my lord, 27. I have paid the conservancy fees. It's coming under the municipal area. Conservancy fees was paid up till 1994.
Yes.
My lord. Then, thereafter, my lord, I have paid for the collection of the premium. At present, there I am in possession, but there is no house. The thing is.
No. Which document says that? Her document saying that you are in possession.
Page report 48. Page 48. During the hearing before the deputy commissioner, the report was called for from the concerned Patwari and survey. It is mentioned, kindly see, my lord. It's written WPA as per the money megle working code. As per local inquiry, our money megle is in mainland for medical treatment. Power of attorney order P. Karnal Police is taking care of her land. Presently, the land lying vacant. The physical field in survey report may be obtained from it. Power of attorney is stated that they are ready to vacate the excess land if found in their occupancy. They have not disposed of the said land and this is the condition has to fulfill as per the press note. Now coming to the press note. This is the inspection done by their own. Page 46. Till the order of the commissioner.
Let her complete, let her finish.
Sir, this is the report.
Yes.
Before the deputy commissioner, I think on her, on his instruction result. Now, my lord. Now, my lord, coming to the press note. Our next, my lord, press note is at page 33. What the press note says, what condition have to fulfill? This is of 2015. My lord, the second para, after this urban area, this much, that is there. Thereafter, those license holders under the said scheme who are in physical occupation of the such land and have not disposed a deposited premium are requested to get the land demarcated, verified, and pay the premium by satisfying the following conditions. Here, after this press note, they have to demarcate the land, verify, and pay the premium. It is, and there are 4 conditions. The licensee is still in possession of land. I am still in possession of land. Their own report saying that I am in physical possession of land. They are not saying house is there only. There is a difficult to construct a house. Why I am saying here? It was a wooden house. And during the period, because it was prior to 1978, I have enclosed. During the period, my house collapsed. When I went before the municipal wants the land revenue reports of rights and sketch plan. Without the paying of this premium, I cannot get this land revenue and reports of right and sketch. For that reason, I couldn't construct the house, new house over there. But I am still in possession.
Your license is liable to be revoked. Your license is liable to be revoked.
Well, I am still in possession.
No, you have not built a house.
Yeah, after the affidavit of operation, they have annexed the, they have annexed the report. Kindly see annexure R1. In that also what it is said, my lord, they have annexed their own report by saying that second paragraph. As directed, self along with SMD attend the field for field inspection of land bearing survey number 23/23/3. But there is no any occupation of licensee in this survey number. Further, as per the occupation shown by the previous report at page and claimed by the licensee, the occupied land falls under 50 and 51. As per 1978 land registered block number 23. As per Bureau of this 23, block number 23 was constructed for the purpose of regularization. During the 1988-89 period, more than 7,000 licenses were issued. More than 7,000. And in this municipal area, the block were created. The concerned area, the head of village, that block was 23. So I am coming under 23. That's why license is 23. In head of village, the survey number 50 recorded as government revenue land. This is survey number 50 and 51. This is of 1961 record number. This is of 1961 record.
All
so
right.
it is a government revenue land and survey number 51 recorded as revenue nala. So they are saying this is coming under 23 only. They are saying I'm not occupying, but in one report they are saying I'm occupying.
All right.
Record. And finally, see the next page, they have mentioned in the order sheet it is there. Next page they have annexed it. It is reflected at last paragraph. It is mentioned.
Go and file a suit. I'll grant you liberty. Go and file a suit.
Well,
For orders
premium.
on Monday.
Monday, after
Hmm?
further hearing.
How long you will argue? I will not hear other matters. You showed me everything you have here. এটা আমাকে বাড়িতে বাংলোতে পাঠিয়ে দাও। They will not accept your premium. There are disputed questions of fact. How can I decide? Go and file a suit. You can always file a suit. Hey, I've heard learned counsel for the parties at some length. Stop. Paragraph. List this matter under the heading for orders at the top. At the top. Huh? No, Monday date. Monday, whatever it is. February 2. Sorry, I've told you what I'm going to do. So, because I have to rise now.
Not the first case, my lord. Every case premium has been accepted. In my case itself.
You have not been found to be there. You have not built a house.
Their own record is there, my lord.
You are saying a house cannot be built. Now, these are all factual, disputed questions. How can the writ court decide? I am not saying that you are not entitled to a relief. You may well be before the appropriate forum. I leave all questions open. Go and file a suit. Sorry, I'll have to, anything
Mr.
else?
Samanta has not come.
Oh my God.
Yes.
Yes.
Of the court and back, if you accomplish my, that is not still.
Anyway, he is not here today now, your learned brother. So let that be on Monday again. Ask him to come back on Monday. So what to do, Mr. Khan?
Let it come on Monday, Lord.
Let it come on Monday.
This other matter is fixed on Tuesday, on 4th. I think 4 or division bench matter. Mr.
Right. He may not be here on Monday also. I
Yes.
don't know.
Right.
So then on Tuesday.
Tuesday.
Tuesday, ওই যে bunch of CO যেগুলো আছে. Anybody wants to say anything? Monday. All right. What she is saying, tell him what your records say.